A message from the Supreme Court at 1 o'clock this afternoon from Justice Marshall to the President. The strenuous demands of court work and its related duties required or expected of a justice appear at this time to be incompatible with my advancing age and medical condition.
I'm saddened by his departure because I know that equal protection under the law will be less protected with his leaving.
He became a legend in the law and a living symbol of the best in American justice. He enriched us all, and the country will be poorer because of his retirement.
Notwithstanding disagreements on specific cases, I think that Justice Marshall made a very unique contribution to the court.
A quarter of a century on the court, and before, it was lawyer Thurgood Marshall who represented black school children in Brown versus Board of Education, the 1954 Supreme Court decision desegregating the nation's public schools. It was Thurgood Marshall who went personally to Little Rock to see that that ruling was enforced.
That we want those children to have a constitutional education, which the Supreme Court said must be on a desegregated basis.
Do you think this country is making progress?
Protected civil rights, opposed the death penalty. Thurgood Marshall resigned today, the last true liberal on a conservative court that is certain to write its own chapter in American law. The impact of the Marshall resignation tonight.
7. The headline was inevitable. The first black ever appointed to the United States Supreme Court. It was a storybook rise. The great-grandson of a slave who shot to the top of his law school class, then spent his life fighting official segregation. In 1954, as an NAACP attorney, Marshall's arguments helped persuade a unanimous Supreme Court to outlaw school segregation. They even made a movie about it.
What is important is that we get the principle established. Segregation by race is not legal.
And when Justice Marshall, now nearly 83, plagued by failing health, announced his retirement from the court today, it was this legacy that was recalled across the political spectrum.
The Supreme Court has lost an historic justice, a hero for all Americans and all time.
I have to tell you that Thurgood Marshall has left a lasting and strong and profound imprint on the law of this country. And with regard to civil rights law, no other person in this country's history has done more from a legal standpoint.
But there is another story here, one that is far more significant than the color of Thurgood Marshall or the color of his replacement. The tenure of Justice Marshall is a symbol of the slow, steady, all but certain end of judicial liberalism. The Supreme Court he joined nearly a quarter century ago, and the court he leaves today, have almost nothing in common. When Marshall became a Supreme Court justice, it was as a fervent member of a staunchly liberal majority. Chief Justice Earl Warren and William Brennan, both Eisenhower appointees, New Deal progressives Hugo Black and William Douglas, LBJ's Abe Fortas, they had helped shape a Supreme Court almost eager to strike down laws that did not fit their sense of what the Constitution required. Could states draw legislative lines that violated the one-man, one-vote idea? No. Could states permit voluntary prayer or Bible reading in public schools? No. Could criminal suspects be interrogated without being informed of their legal rights? No.
We have our legal arm, and we have our political arm.
Marshall joined this liberal majority wholeheartedly. In his time, the court opened the door for publication of the Pentagon Papers, found a constitutional right to abortion, upheld affirmative action, even ordered a president to release secret tapes. To some scholars, this activist court was a blessing.
This is the end of the era of the liberal court. It's true that Justice Marshall was alone on many issues after Justice Brennan left. The two of them were the last liberals who painted with broad strokes.
To others, it was a curse.
I am not sure that Justice Marshall, over his time in the court, has sufficiently taken into account that he is an unelected official and that the elected branches of the government ought to be the primary source of policy making in this country.
But whatever happened to that old liberal court? As Finley Peter Dunn once put it, the court followed the election returns. Today's Supreme Court is far more conservative, far less likely to strike down criminal laws and public policies of legislatures or the Congress. That's why the prospect of a new conservative justice alarms advocates of abortion.
The Supreme Court obviously is now stacked with people who do not see that the Constitution protects the right of speech with respect to abortion. So it does not take a wild imagination to think of the possibility that they would not see the constitutional protections for abortion.
That's why others cheer the prospect of a tougher outlook on criminal justice.
I think that the court today recognizes that while we may not abridge the rights of criminals within the criminal justice system, at the same time, the role of victims is a very important part of the system, and furthermore, that the role of the interests of society as a whole cannot be overlooked when we begin paying attention to the rights of criminals.
In later years, Marshall was an increasingly isolated voice of dissent on the court. His frustration, some called it intemperance, was on public display last year when Sam Donaldson asked Marshall his opinion of President Bush.
Let me put it this way. It said that if you can't say something good about a dead person, don't say it. Well, I consider him dead.
Who?
Bush.
He's still alive, Mr. Justice.
Damn right he is. I just don't understand what he's doing. I don't understand.
His absence now, liberals say, means that the court will no longer be a place of last resort for the powerless.
What you have to remember, and what Justice Marshall knew, is that there are some minorities who may never win